Namaste, good evening. Welcome to this 63rd AAA weekly webinar series. Along with Ankit, I give my greetings to all of you who are coming every week in huge numbers. And that's a respect that you are giving to us by attending to our webinars. This is 63rd webinar without any gap. At times, some difficulties have also come, but then we have somehow managed it, somewhere in train or at the airport. But yes, thanks again to the AAA team for giving every time a new subject. So Ankit, today the subject is very important. It is much in talk. There are very many seminars and webinars are happening. The objective of this particular webinar is to seek discussions and seek also the suggestions from public at large, so that we are also able to give these suggestions to lawmakers, to our regulator, IBBI. So the discussion would be on the discussion paper released by IBBI on 7th June 2023. The objective of that discussion paper is to propose some amendments which are required for faster resolution and also some of the anomalies that can be removed. So Ankit, I'm sharing my screen.
Yep, let's go ahead. So two very, very important discussion papers that we're talking about today. So let's go through these and looking forward to questions, suggestions on the Q&A box so that we can take them up.
Okay, so we are now on discussion paper on measures for increasing possibility of resolution, value of resolution, and enabling timely resolution. The discussion paper was issued by IBBI on 7th June 2023. And again, thanking the AAA team for making all this research. When we see the primary objectives of this discussion paper and the amendments in that discussion paper, we could see that the objectives are: one, time-bound resolution, maximization of the value of assets, stakeholders to revive a viable company, and only if it is not feasible to viable, then liquidate the company. The major criticism to the insolvency law which has happened since its inception, or especially in the last 3 years, that fewer companies are being resolved, lesser value realization as compared to the claim. So the word which is called haircut, which is a misnomer, that is also something which is misused by the critics of this insolvency law, because they are saying that the claims are higher and the recovery is lesser. What we are trying to say, that the claim do have the compounding impact of interest, also the various litigation charges, also the penal interest, and also the liquidated damages as per the agreements of the banks. However, if something is not recoverable, now we have to see what is recovered as against the options available with the bank. If the options available with the bank are three, one may be SARFAESI, the other may be one-time settlement, and the other may be insolvency law. So the best outcome is still out of the IBC. The only thing that we have to manage is the delay in the process, and partly it is on account of the country's infrastructure. In case the infrastructure is improved, I believe the delay also can be reduced. The time taken for such resolution is longer than what the law prescribes, but yes, that's where some of the regulations are proposed to be amended, and we will just take up one by one. First is the timeline for providing information for assignment of debt. It is nothing but an anomaly, like whenever, like as I understand, as you also understand, that during CIRP or even during liquidation, it is possible that any creditor can assign its debt to any other person. So that is happening. Even the banks and the financial institutions, they are clearly looking forward to have ARCs or AIF for assigning their debt. Wherever they see that the quick money which can come from ARC or from AIF is better than going through the resolution, so they are preferring assignment of debt even during CIRP or during liquidation. However, in case we complete our insolvency process on time, in case the Section 7 applications are heard within 2 months maximum, in case the resolution plans are approved within maximum 2 months, then all these assignments will not happen. However, presently the IBBI is proposing that there is a timeline that whenever there is any kind of assignment, the assignee and the assigner both are required to submit their documents, their identity, and with full transparency, they have to submit this to IRP, IRRP, or the liquidator. However, the liquidator is supposed to inform to the adjudicating authority within 2 days. It is only a kind of anomaly that the assignee and the assigner are not under any obligation to inform the transaction within a stipulated time. So there is a timeline for the IRP or the RP. There is no timeline for the assignee and the assigner. So now there is a proposal to provide a timeline for the assigner and the assigner, and that is 7 days. Whenever the transaction is completed, the assigner and the assignee, they are supposed to inform to IRP within 7 days of the transaction. Welcome change, but then doesn't impact the timelines or doesn't impact anything else. It is an anomaly that all the responsibilities are with IRP and the RP. So now there is some responsibility to the assigner and the assignee also.
So question here that comes up is that what happens in case there is a delay from the creditors in giving this information? What is the result, or what is the implication on the creditors? Because if we say that yes, there is a timeline for them to inform, and if they submit this change after the timelines have lapsed, and the RP says, no, I will not accept this change because this is outside the timelines, then it will simply cause another filing before the NCLT and them granting this delay as okay. So what is the implication that needs to be understood? So one can say that yes, within timeline it is, if it is filed, then maybe we can say that it will be without any charges. But if it is delay filed, then maybe there has to be some kind of a fee associated with the delayed filing, so that the process continues without another application to the NCLT.
So when this discussion was going on, I still remember that I also gave a feedback that the delayed claims should be accepted by the RP with some kind of late fee. Yeah. But that was not accepted because our regulator thought that once this process would start, it will start another kind of criticism. So I think the implication of non-compliance by the assigner and the assignee is not dealt with in this regulation. So this can be one of the very good suggestions that we also should add some implication in case it is not informed to RP or the IRP. So one implication can be that the IRP or RP is not empowered to accept this assignment. Then another litigation will start. The assigner or the assignee will say the kind of arguments which are like they were restricted by unavoidable reasons and all those. So it is not really possible that an assigner or assignee can be kept outside the process in case the amount is significant. However,
and if they are kept outside the process, the entire decision making in the COC would get delayed. So sometimes the assigner and the assignee can be a very large part of the COC.
So having a regulation is better than not having a regulation. Now, having in the absence of any penalty or any penal provision, we can still say that there will be 80% or 90% compliance to this. I think presently we should all be very happy with 80% or 90% compliant, because the non-compliance only happens in something like 10 to 20% of the cases. So for the time being, there is a correction for about 80%. However, we'll see, like as far as this penalty is concerned, most of these members would be members of the committee of creditors. Whosoever will be assigning or assigner, they both would be, one is the existing member, the other is a proposed member. So they, in any case, in case of any delay in the process, they would also be sufferer, because the CIRP cost will deplete the value of recovery for them. So one, that there is a regulation. Number two, even the adverse impact is also on the creditor. It is not on the other party. So if the adverse impact is also on them, then I believe there would be more than 90% compliance to this particular change. So therefore, we also don't think that there should be any penal provision, because even the resultant delay and the resultant increase in the CIRP cost would also be borne by those creditors who are the assigner or the assignee in this case. Is it okay, Ankit? Can we go ahead?
Yes.
Okay, now the seeking information from personals of the corporate debtor. Like this is, the difficulties are, the IRP or the RP like is taking information and the documents from the personnel of CD is a difficulty. This causes delay in the process. Now let us see what exactly Regulation 3 capital A has proposed. So they actually have done, it's something which is good, that there should be some kind of documentation while we take over handover from the promoter. This is scenario number one, that we get the handover from the personnel. Now the personnel are defined. I'll come to that. Who are the personnel? In case we get the handover and the custody of assets and records, that is one process. Number two process is that in case we don't get the custody and control from the promoters or from the personnel, that means that the IRP or the RP is taking the custody himself. That's a second scenario. So these are the two scenarios where this entire regulation has been divided. Now, the very first is like who are the who all are responsible for handing over the assets and records. Number one, personnel of the corporate debtor, and that's what is decided as comma, its promoters. And any other person associated with the management of the corporate debtor. All in this particular conversation that we are now talking, all will be considered as corporate debtor. For the purpose of this conversation, we are saying that we will just refer them as corporate debtor. As far as the definition of personnel is concerned, the definition provided in the Companies Act, that would be taken as the definition of the personnel. So these are the people who are responsible for handing over the assets and records. Now, I think one thing is very, very important to record, that it is assets and records. Both are required to be given to the IRP or the RP. How the handover should be done? In case the handover is being done in a very, very cordial manner, the personnel, so means the corporate debtor, are handing over the documents and the records and the assets in a legal manner and lawful manner. Then what is provided in the regulations, that the IRP and the IRP would prepare a list of assets and records which are handed over to the IRP or the RP. And that list also should have a kind of signatures of the personnel of corporate debtor, that yes, we have handed over this to IRP. So this is one scenario when they are handing over. Now the other scenario is when the corporate debtor is not handing over the documents, records, assets to the RP. Then what the RP will do? RP will prepare a list of assets and records while taking over the custody. Like what we do in SURFACE when we coercively go and take the possession of the assets which are security interest under SURFACE. In our profession, that we've been doing it for the last 22 years. And that's where we might have taken possession of about 9,000 assets so far. So there is a document called Panchnama that we make. And the proposal now that has been made by IBBI is also like Panchnama. We have done Panchanama in many of our insolvency cases. Now it is defined. Earlier, we did it as a best documentation part of it. Now, what they have said, that in case of the list has to be prepared by the RP when the assets are taken, when the records are taken from the office of the company, from any other third party, from any other person. So that list must be prepared. Now, when that list is prepared, there should be signed by the parties present. Parties present means any person who is handing over, any person who is taking over. These are parties present. And by at least 2 individual witnesses who have witnessed the act of taking the control and custody of on such assets and records. So that means person taking over, person like present in the meeting means taking over and handing over. So in case there is no person who is handing over, that means the team of the IRP is only going and taking the custody along with 2 witnesses. So those 2 witnesses will also sign. So that's a record that what we have taken over today, assets, records, a combination, a kind of list that will be made. Then after that, RP will give a notice to corporate debtor. When I say corporate debtor, all that is defined under the definition of personnel, which is personnel, promoters, any other person who is supposed to have a item of records with them. So the notice would be given by the RP. The notice would be given based on what? So the RP will say that I have some balance sheet with me, which is maybe older or which is maybe recent. And based on that balance sheet, I need to have the possession, control, and custody of these assets. And these are the name of those assets, which I could not get on the premises. The insolvency professional can always say that I could not get the fixed asset register, therefore I could not match it with that. So I need fixed asset register. Then the records which are defined in section 18(1)(f), those are also the other records that would be required. So in case we actually have to go to see what is provided in 18 IBC. Can we take IBC? Like too many documents are open. Okay, so let me open the IBC. We have to see 18(1)(f). So So 18(1).
I think you have to open the one of the amendment acts. So this is not the IBC. This is not IBC. Yeah, this is an amendment act.
So duties of the IRP, and then we see the 18 A, B, C, D, F. So 18 and then 1 and F is the take control and custody of any asset over which corporate debtor has ownership rights as recorded in the balance sheet of the corporate debtor or with information utility or with the depository of securities or any other registry that records the ownership of the assets. Now, including assets over which the corporate debtor has ownership rights, which may be located in a foreign country, assets that may or may not be in possession of the corporate debtor, tangible assets, whether movable or immovable, intangible assets, including intellectual properties, securities, including shares held in any subsidiary of the corporate debtor, financial instruments, insurance policies, assets subject to the determination of ownership by a court or authority. And these are the assets which are required to be taken over by the corporate, by the IRP. So therefore, we need to prepare a list of all these assets and give a notice to the CD. CD means to all these persons, like the personnel, the promoters, any other person who is likely to have this information. We have to give this notice whose custody has not been handed over to you. So one, the custody handed over by the promoters. Two, the custody taken over by the IRP. Three, making a list of all those items which has not come to him and he needs that. And those are the items which are stated in section 18(1)(f). And then also proving that these assets have not been handed over to me. Now the information relating to the assets, finances and operations of the corporate debtor as referred to in section 18(1)(f). Now in case we see the 18(1)(f), 18(1)(f) we have already seen. In fact, 18(1)(a) we should see. So in 18(1)(a), collect all information relating to the assets, finances, and operations of the corporate debtor for determining the financial position of the corporate debtor, including information to business operations for the last 2 years, financials and operations payment for the previous 2 years, list of assets and liabilities as on the initiation date, such other matters as may be specified. So these are some of these details which are required in section 18(1)(a), which were required to be maintained by the corporate debtor but have not yet been handed over. So now we have seen the RP's duties to first take over from the personnel. Second duty is take over automatically. Third duty is to make a list of all those assets which are required as per section 18 subsection 1 clause F. Then RP's duty is to list out all the assets which are required or records which are required under section 18(1) subsection A. Then when all these lists are prepared, then the CD, the personnel, should be informed about all this, that this is what is required. Then section 19(2) application is expected now. After all this is done, then section 19 subsection 2 application is advised. And in that application, all these notices, all these lists, whatever we have prepared, whatever the notices we have given to the CD, all those has to be attached. And then we actually have to showcase to the adjudicating authority that these records, these assets are still not handed over to me. So this is what is the regulation, Ankit. Now I need your comments on this, Ankit. What exactly you think and what we can ask from our audience, whether they have any suggestion on this. If they have any suggestion, Ankit, they should write in the chat box or in the question answer box, and then we will be able to discuss it. Yes, Ankit.
So I'm just checking if there are any questions. We have a few questions. So one of the 19(2) questions is that if 19(2) applications in NCLAT remands order of NCLT, thereby RP is left standing without getting info for months. So I think this was concerning the earlier period that the information may not come, but then basically now with the new process, in case it is very clear that yes, this is the information that was received and 19(2) applications are attaching that notice. So the first layer of of asking for information gets a structure, and that structure is a welcome thought process. Although the current communication that we as RPs do with the ex management is through emails, and one can always have multiple rounds of discovering certain information. So say you get appointed as an IRP, you do a search on MCA, dig out the balance sheet of the company, then you see in case any other balance sheets are available from other sources. So the information that we ask keeps increasing. And I think the new thought process now is that our IRP should have a list of a pre-thought list of or a checklist of documents that should be customized for each case that they need to ask from the CD. And when they take the custody and the possession, this notice should actually be a comprehensive notice such that only those items can be or should be added later that could not be anticipated and when the notice was issued. because the importance of this notice now has become very important, very important. Since 19.2 applications would also be based on the notice. So because this is a constant fight that in 19.2 applications before NCLT, the promoter would say, no, I gave this information, and the RP will say that I have not received this information. So that I think will get a little structured through this process.
We'll just say, Ankit, what is the intent? I have also seen the intent of adjudicating authority. Adjudicating authority says very clearly, like after filing application under section 19 subsection 2, the IRP or the RP should make efforts to take the information and also take the custody and control of the assets. 19.2's application is not a final solution. It can only be a solution where some directions are required to be given to some parties. This is also a requirement of the valuers, that the inventory of the machines, inventory of stock items, inventory of consumable stores, that has to be made by the RP or the IRP. The valuers are saying that this is not our duty to go there, inspect the items, make a list, and also value it. So now, whenever a new case comes, so all these steps, step number 1, to try to take control and custody of all the assets and records from the personnel of the CD. In case such cooperation is not getting extended, then make an effort yourself, make a list. So that's something which is a very, very kind of additional job, which is now casted upon the IRP, RP, and also to maintain the documents and records what has been handed over to our IRP, RP. Now, in case of companies where multiple locations are there, multiple offices and huge kind of records are there, still it becomes very difficult to go with the team, make inventory, and also then thereafter, like as far as the promoters are concerned, if they are not supporting, then they are criticizing. So there is nothing like in between. Either they will support the process or they will create hurdles and they will criticize each and every action of the RP. So in both these scenarios, in case they are cooperating, it may go good, but in case they are resisting, then it will still be a kind of fight between the IRP and the promoters, that the promoters want least information to be shared. Promoters want most of the assets to be hidden, but the IRP wants all the transparency, all the assets, all the records should be handed over. So the difficulty is still there. The responsibility of the IRP or the IRP has gone up very high. Each and every photograph, each and every video we have been taking, but that is not sufficient now. It is sufficient only in case we have a list which is duly witnessed by 2 independent individuals. And also after that, we should prepare that list. We should compare that list with the number 1, the records available in the balance sheet. Number 2, records available in information utility. Number 3, records available in the depositories. Number 4, any other public domain. Then we compare these records with the items that we have received from the promoters. For the differences, we have to prepare a notice to the CD, and all personnel should get this notice. And after we send them notice, then we have to give all the details to adjudicating authority. When we went, what we could find. This is the list when we went. This is the list when my person went there. And when my person went there, we actually went with these particular witnesses. Now, who are those witnesses? If the IRP take witnesses along, or in case there is nobody on that particular asset, then the witnesses has to go along. So I think the COC would understand the impact on the cost, that every list has to be prepared. The witnesses has to go and travel down. it is not really possible that I can find witnesses at that location who actually can be made available for any kind of future witness in the court. So that means that the IRP will have to take witnesses also in case the promoters are not cooperating. So this is what is my understanding about all this process that has been done. So Ankit, is there any question on this or any kind of suggestion which is coming from anyone?
There are about 13 questions and comments that we already have. And basically, I think we can go ahead with the structure that we are following right now of the presentation. And maybe we can take the questions after some time. I can filter out some of the questions that are more important than others.
So yes, and the next is the modification of timelines for submission and consolidation of claims. Now, the present regulation says that the IRP-RP can deal with the claims up to 90 days. Deal with the claims means either accept or reject. Deals with the claims which are received up to 90 days from the commencement of CIRP, the proposed regulation. However, what are the difficulties and challenges in the present regulation? Now, what happens is after 90 days, the RP has got no power to admit a claim. RP will say that I have no power. And in case we give this power to RP, then the transparency actually would be slightly considered as reduced. But now a lot of litigations are pending before the court, and a lot of litigations have been disposed of by the adjudicating authority regarding claims, which are primarily belated claims. Now the proposed regulation says that the creditor may submit a claim not later than the date of issue of RFRP under Regulation 36 capital B, or 90 days from the insolvency commencement date, whichever is later. Now it is later. Now, in case we see Regulation 36 capital B, it says that the RP will release the expression of interest. It is now 60 days, and then thereafter certain dates, and after a date the RFRP would be issued. Now the even date of release of RFRP has been changed in this particular proposal. It is now, I believe, 105 days. Now, when we look at Regulation 36B, it says that the two processes can be conducted. So if there is any modification in the RFRP, that will be considered as a new process. So RFRP, request for resolution plan, from that date, after that, no claims would be accepted. After that, no claims would be accepted. But then when we read Regulation 36B, that means even the second RFRP is also under Regulation 36B. And even if in some cases the court may authorize to release third expression of interest, that is also as per Regulation 36 capital B. So what I'm trying to say is, even the first process fails, in the second process also the claims can be submitted. So this is almost more than 75% period of the CIR.
This is in sync with also what the courts have said. NCLT, I think, has several times said that till this stage, if the claim is admitted, then you can actually take it into account. Now, the only claims that will be left after this change between the RFRP and the is the date of the RFRP and the resolution plan approval date. So those claims will be the only ones that still can have a dispute. My only suggestion here is that one of the reasons why creditors do not file their claims in time is that they wait and watch and see in case the other creditors are if there is any contribution being sought from the other creditors. This is one of the larger reasons why many creditors may not be filing claims. So one of the changes in this regulation that can happen is that even if a claim is filed on a belated basis beyond till the RFRP date, the creditor can be asked by the RP to contribute the proportionate cost of CIRP for the earlier period as well. If we bring that here, then it will stop being an incentive to file the claims late.
Yes, you're right. But then now the proposal is that the RP will keep receiving all these claims, and RP will finally consolidate these claims into two parts. One part where all those claims would be collated, which are acceptable for condonation of delay. And the second is all those claims which are unacceptable by the RP and the contestant for some reasons. So now both the claims are received belatedly. The RP is still dealing with these claims, and RP is providing their comments that are acceptable for condonation of delay. That means that the RP is admitting those claims, and there are some which the RP is not committing. Then an application has to be filed with the adjudicating authority by the RP, and that application should say that all the claims received belatedly gets divided into two parts. One part where I also feel that the claim should be accepted, but the delay has to be condoned. Second part, which says that the claim I have received and I have not sent any acceptance letter to that claimant, and however, these rejections are contested by the claimants before the RP. So in this case, one IA can deal with all the belated claims which are accepted by or which are acceptable by the RP. Also, this application will be dealing with those claims which are not acceptable to RP, and those are contested. Those claimants have contested the RP's version. So all this application will attend. This application will be filed by the resolution professional or IRP, and after the application is filed, then the court will decide which counterclaim or which is an appeal before the High Court. So that is where the result will come. Now the result would be that one application and all may be made as a parties. But then the IBBI very clearly says that there is even if the RP files an application, it does not take away the right of the rejected claimant to file an appeal or file an application to NCLT. So Ankit, when I am seeing this clause, I was seeing that even in this case, when we see the pros and cons, so the challenges that I can see, that the potential for delay, because there is a sleepy attitude which will flourish amongst the claimants, and then also the intentional delay by some of the creditors, because the creditors will say that if our claim would be admitted, then the CIRP also would be asked from us. But they are simply not interested to participate into the CIRP, some of them. So therefore, they will delay in submission of the claim. Then the other challenge is that it is an added responsibility on IRP, RP. The number of times the reconstitution of the COC would be done. Because in the entire regulations, I haven't seen that this particular facility is only available to kind of Ankit, I think you need to see if there is any question on this, but then I think this will actually cause some delay. Some sleepy people, they will not file because they will be participating into the contribution of the CIRP cost. And also, it is the financial creditors' claims will come delayed. Every time the claim will come, the committee will be required to be reconstituted. So that will also increase the litigation. So some deterrent should be there for the creditors. And that one deterrent that I can propose is the COC should be constituted maximum 2 times, and no participation in the COC of those people who have submitted their claim after 90 days, and they would not be able to induct in the COC as members. This is only one suggestion. I'm not sure whether it's acceptable or not. So yes, Ankit, now you can provide your comments on this.
So I think yes.
And also read some of the newspapers, some of the questions.
So two things that are important that you have already said, and I think I have communicated that the CRP cost should be borne by the creditors who come in later, and the other deterrent that you have suggested is also a good idea, that they should not become then allowed to be part of the COC within 90 days. This is maybe a good idea to limit this responsibility or limit these delayed filing of claims. Then I'm just going through the question, and so of course some questions and some comments are talking about how the NCLT takes a lenient view with respect to accepting delayed claims, and that is something that is now proposed in the provisions or in the in the regulations as well. Then of course so what do we do when the CD lenders IRP RP doesn't have or don't provide details, mostly in case of valuation of plant and machinery, like technical details? Is a valuation related question. I think we can take it later. One of the questions that is important here is that when we looked at 19.1, do statutory auditors come into the ambit of any other person associated with the corporate debtor?
Yes, it do comes. It has already been accepted by the various courts, and the various courts have actually been sending notices to statutory auditors that whatever you have, you should provide it to the IRP or RP.
When we prepare a list of documents or notice of what documents are required from you, then there would be also a notice that we will prepare to send to the statutory auditor that you should have these records as per the auditing standards or accounting standards, and you're requested to then provide these to us. And then you can subsequently then file an application against the statutory auditor as well to give that information to you. So documentation for auditors also becomes important due to that change. Then Sandeep ji says, many a times assets of the CD are spread over multiple locations and proper fixed assets this is not maintained. In such a situation, what is the best way to take custody of the entire set of CD assets? So I think we have to prepare a list. We have to note in that notice, and we have to mention in that notice, as Anil sir already shared, that FAR is not available. And of course, videography, photography, and then proper listing of all the assets. Proper witnessing of all the assets located there, that should be the norm.
Going forward, Ankit, we should now, because the time is also very important, increase of the duties of the authorized representative who are appointed under section 25A of the code. Now, the regulation 16A of CIRP regulations is proposed to be modified, and there are 10 regulations which have been added as sub-regulation 10 to 19. So these regulations are saying that the authorized representative of the real estate allottees or the deposit holders or the public deposit hold or the debenture holders or any other who actually is entitled to as a class of creditor, the authorized representative should have more responsibilities than the duties. Now, these are the responsibilities, and he's supposed to assist the creditors in understanding the discussions and considerations of the COC meeting to facilitate them in informed decision making. Review the contents of minutes prepared by the RP to ensure correctness and completeness. The authorized representative is also work collaboratively with the creditors to enhance the marketability of the asset of the CD. So this is something that's additional. Now he is also expected to bring some resolution applicant. Provide assistance to the creditors in evaluating the resolution plans submitted by the resolution applicant. Maintain open and frequent communication with RP, ensuring that the creditors have access to information or documents required to form an elucidity and required to form an educated perspective on issues discussed in the COC meetings. Regularly update the creditors on the progress of the CIRP. Act as a representative for the creditors in the interactions with the NCLT and NCLAT and any other regulatory authority. This is a very heavy responsibility, that he is also supposed to act as a representative for the creditors. So there can be two meaning of the representatives. One, that all the applications which are filed by the class of creditors can be signed by the authorized representative. And also, like in case interaction for the creditors in interaction with NCLT. Interaction also means hearing, representation. So that means that he's supposed to be there in the hearing or in the NCLT, or NCLT litigation process. Assist in modification of resolution plans as may be required by the creditors. Take due and reasonable care to record proceedings and prepare the minutes of the meeting with the creditors in a class he represents. So now the AR is also having a power to convene meetings of the class of creditors. So in that meeting, the AR would chair. And in that meeting itself, it is said that whatever is the discussion with the class of creditor, that has to be captured in minutes. And how the minutes will be prepared? All the regulations of conducting meetings and circulating minutes as provided in the CIRP regulations applicable to RP or the IRP, that would be applicable to even authorized representative. So he would be sending all kind of communication to the class of creditors. Now the minutes of the meeting has to be recorded. The creditors in a class may propose any additional responsibilities upon the AR. Keeping in mind its interest, such responsibility shall be recorded in the minutes of the COC meeting. Additional assist in modification of the resolution plan as may be required. Take due and reasonable care to record proceeding. This is done. And the creditor may propose any additional responsibility. No, when I say the additional responsibility, can the fee of the AR be increased in case any additional responsibility can be given to AR by the COC? Then in that case, can the fee of the AR be increased? My understanding is whatever duties are given to AR, the basic fee would remain, as you can see on the screen, up to 15,000 class of creditors. It will be up to 100. Up to 100, it will 30,000. Between 100 to 1,000, it is 40,000, and more than 1,000, it is 50,000. So it is exactly double the existing rate. And also there is a separate fee proposed for convening the meeting of the class of creditors by the AR. In that case also, the fee would range from 10,000 to 15,000. So these two things are very, very important. Now they have also made a provision that how the AR can be replaced. Now for the AR to be replaced, in case some AR is not functioning, or the AR is not interested, or he is not having the requisite infrastructure, then the class of credit can replace the AR also. They can replace with the voting, and they will also give the choice of insolvency professional as their choice for the purpose of replacement. The IRP and RP shall circulate such request to the creditor in that class and announce a voting window open at least 24 hours from such circulation. Now the IRP, RP shall offer choice of at least 3 IPs to the financial creditors in the class, including such IPs. So that is the choice offer. The choice of highest number of financial creditors in that class will be ascertained by voting. RP shall apply to adjudicating authority for appointment of an AR who is the choice of highest number of the creditors. So Ankit, we have finished another subject now, like the kind of additional responsibilities of the AR. and also replacement of the authorized representative. So we can
I
take
think this is a
break
very
for the
yep,
questions.
but the question can be that is there any change in the remuneration for AR?
No, the remuneration has been changed. It is like the existing remuneration 15, it is increased to 30. From 20, it has been increased to 40. From
The
25
scope
to
of
50.
work. So with the scope of work,
With this cover,
this
the remuneration is
also
changed.
amount.
And
So that's
also,
also a welcome step. And I
also
believe
the AR will
the
be also the AR will be getting the fee for the meeting that he's conducting with the class of creditors only. Yes.
so that's also a welcome step. So I think this is a good idea. The change being allowed, and it will allow the AR to have a larger role in the whole process. And currently, they are the we kind of sometimes people tell us that AR is more of a postman. He just delivers the communication of the RP to the creditors and from the creditors to the RP. So now that I think role will become more effective.
Now another proposal is the inclusion of minutes of the COC meeting in Form H, where resolution plan were discussed and decided. So the minutes of the meeting is also very important. So earlier in Form H, it is not there is no row for discussions on minutes of the meeting, but now they have changed. And minutes of the committee of creditor meeting concerning discussions and decisions about the resolution plan, that is also one of the paragraph which will be added to Form H of IBBI regulation forms. So that's okay. That's very reasonable. Then we can see there are participants who are actually have raised their hands.
So AR needs to be an RP, right? IP can only become an AR. Yeah, that's
has
very
to be an
clear.
RP.
Yes.
Now, regarding the another issue, which is regarding the limitation in the applications for initiation of CIRP, there are a lot of litigations have actually resolved and a lot of pending also. Now, the crucial to address the aspect of limitation as very inception of the insolvency process is being introduced. So they have introduced regulation 2D, which says that along with the application under section 7 or 9 for initiating CIRP, the financial creditor or the operational creditor shall. So what are their obligations? Number one, submit an affidavit providing a detailed chronology of debt and default and explaining why the application is not barred by the limitation. So this is some information which has been sought from the creditors, that this way information should pass on to the IRP or the RP. The affidavit should detail the date when the debt became due, any subsequent acknowledgement of the debt or the part due, if any, and the period of limitation applicable to the debt. Now we go to, so this limitation part, that has to be kind of a part of the application, so that the adjudicating authority to discuss this thoroughly, and the application should not get rejected unnecessarily. So this is also a very small change, but very, very significant change. And we can now go ahead, and or Ankit, you have something to say.
I think we can go ahead.
So now we can actually say that now another concept is being added in the IBC, and that is called favorable voting on more than one resolution plan. So what is happening nowadays is that there is some anomaly which has been found in the market, that when this regulation all the resolution plans which are should be submitted before the COC to discuss, delve, and approve. So that's what is the present scenario. Now they're saying that this particular scenario needs some kind of tweaking. So what is the tweaking? So they observe that there are many creditors normally in the CIRP process, and the favorable voting on more than one resolution plan, yes. and the creditors are voting on almost all the resolution plans, because if somebody has a exclusive charge on any asset, he doesn't know which resolution plan will be approved by others. So he will approve all the resolution plans because he doesn't want to be a dissenting creditor. And today he actually gives vote to one resolution plan, and later on the other resolution plan gets approved where he didn't vote. So he will be a kind of dissenting creditor. So he doesn't want to be a dissenting creditor because the dissenting creditors will get only liquidation value. However, he is expecting something which is more than the liquidation value. So therefore, he will only he will make sure that he is not a dissenting creditor in any of the resolution plan. So most of the people, they have exclusive security. They are presently voting on all the resolution plans. So whatever resolution plan is approved, I would be protecting my asset and I would be able. This is the reason why transferable vote is introduced. It's a single transferable vote that in one particular voting pattern, you actually have to give your preference 1, preference 2, preference 3, preference 4, etc. So in this case, when the preferences are given, so those would be considered on seeing the first preference, then second preference, and the third preference. So there are illustrations in the discussion paper. To my understanding, these discussions would actually this amendment, although we never felt the like on the need of it, it may be a technical feedback that there is no protection to that person who actually would like to become dissenting creditor. Therefore, he is opting for all the resolution plans. So now this single transferable vote, which has been introduced, it is at the resolution plan which is receiving the highest vote as a single transferable vote, but not less than requisite vote, shall be considered and approved. So this is the first scenario, that if all the resolution plans are put to vote, whichever gets the maximum single transfer votes, that would be accepted. Where 2 or more resolution plans are received and equal votes, but not less than requisite vote, then the COC will approve anyone based on the tiebreaker formula. The tiebreaker formula has to be announced. Even it has to be announced in RFRP. So that is something which is very important, that the tiebreaker formula must be there so that the company gets resolved. And the third scenario is that where none of the resolution plans receives the requisite vote, the COC may again vote on the resolution plan that received the highest votes, subject to the timeline under P. So this was present jugaad, that if the none of the resolution plan is approved in the meetings by the COC, then the COC shall again vote on the resolution plan that received the highest vote. These are the scenarios that we have now. Now, the single transferable vote is that the voter casts a single vote, and in that single vote, the voter will give their ranked choices, that I will give my first vote to this resolution plan, second to this, fourth to this, fifth to this. Voter have an option to rank plans. On that, of course, is first to second hit plan, they can do that. Their vote may be transferred according to the market backup reference if their sorry.
So I think this is very similar to what we do. I remember, I think this is how the institute elections also happen, where you get a first preference, second, third, and so on. And I think this is a good change, because giving the same rank or same vote to all the plans is not a good idea. A ranked ballot would always give a better decision making to everyone. So I think this is a good idea.
This is a good idea, but this is exactly the same as our Institute of Chartered Accountant or Institute of Company Secretary or Institute of Cost and Management Accountant.
It's already a well accepted method for voting on something, and I think this is a good plan here also. And I think, but why only resolution plans? It can also be introduced in other decision makings if they want to extend this to other thought processes.
But
Because
in the other
sometimes
we do not have choices, no?
So in an AR, there is a choice where one has to select one person. So there, the maximum person then kind of gets the votes.
Yeah.
Similarly, when the RP is getting selected, and rather there is a voting on RP approval, P approval, or RP approval, there again, sometimes that approval might miss by a small percentage. And there might be contesting RPs who are getting a share of the different votes.
I think this the last one that we will take up today, and the changes in the timelines. It's very simple. So there are only two significant changes in issue of RFRP, including evaluation matrix and IM. It is reduced from 105 days to 90 days now. This was also a kind of error earlier. Submission of information memorandum to COC. The timeline is 95 days from the commencement date. Since information memorandum is a dynamic document, some flexibility is provided. So what is that flexibility? That flexibility is that if the information memorandum is not available within such time as specified in this sub-regulation, the resolution professional is obligated to disseminate it to the persons mentioned above as promptly as possible. So some flexibility has been provided because the updated information memorandum is very important. So that now we can provide as the information to the person who actually, because we are obligated to disseminate information, so we'll keep doing that. So this was the one, and the last is the audit requirement for the CIRP cost. And the like it is the reasons it is said that the substantial implication of these costs in the larger CIRPs, the proper management and verifications of that cost is paramount for maintaining transparency and accountability, and also the trust of the creditors. Additional measure is intended to bolster financial accountability, enhance confidence amongst all stakeholders involved in the CIRP. That's what I said, trust and confidence. Expenses incurred towards the audit of the insolvency CIRP cost shall also be included as part of the CIRP cost. Now, this is applicable only to those companies where the size of the assets in the balance sheet is more than 100 crore. Whatever balance sheet is available online or from the promoters, if the size of the asset is more than 100 crore, then the auditor has to be appointed. Now, the timeline is that whenever a financial year ends, from the commencement of the CIRP, whenever a financial year ends, there has to be an audit. If there is only one financial year, it is the one financial year is when the financial year ends, that is the audit. And second audit would be probably when the CIRP finishes, when the resolution plan is approved. So there can be one audit in one case, some other cases are 4 audits, because as when 1st March comes in a last audit of the CIRP.
You'll have to repeat that last part because there was a breakage because of the disconnection.
So I'm
Just the last few seconds.
So I'm saying the audit would be done only as on a particular end of a financial year. If the CIRP
won't this be a repetition where the RP is required to audit the financial statements from a statutory audit, and then the auditor is also required to get the CIRP cost separately audited. So the CIRP cost will effectively get audited 2 times.
Ankit, what I think is that the CIRP cost is a very, very sensitive issue for the committee of creditors. They also have to maintain a good relationship with the RP. They don't want to say very aggressively that we need to see the vouchers and we need to see all your traveling expenses. So it is important that they should actually get a report from an auditor. So in case they will have any difficulty, they will rather talk to the auditor rather than the RP regarding the CIRP cost. So this is a welcome scenario. And as I said, in case the first financial year after the commencement of the CIRP ends within 2 or 3 days, 3 months of the commencement, that is the first audit. The second would be the end of the next financial year. Third would be the end of the next financial year. Fourth would be as on the end of the CIRP. So these are the number of audits that would be conducted. Now the auditor who is the auditor who can be appointed? If first of all, it has to be a chartered accountant and also an insolvency professional. The disqualifications are as per Section 141 of the Companies Act, and also who is a related party to CIRP or the IP or the insolvency professional or a consultant or an advisor in any other capacity to this process, basically to avoid the conflict of interest. So this is the discussion paper released on 7th of June 2023. We could not take up the other part because of the shortage of time. Maybe that we come again and we will be discussing that the process of registration and the education for the purpose of becoming an insolvency professional. There is another notification which has come from Ministry of Corporate Affairs. That notification has come in Section 14 of the IBC, because in case we see Section 14 of the IBC, it is very clearly written that the government will, I will just take you through Section 14, and it is actually mentioned in this particular section that such transactions, agreements, or other arrangements as may be notified by central government in consultation with any financial sector regulator or any other authority. So there was no notification in this. However, now the notification has come that some kind of agreements are excluded from this excluded from the moratorium. So some revenue sharing agreement, some kind of space sharing agreements, some joint ventures in the oil and natural gas field. So those are all a very small notification which has come from Ministry of Corporate Affairs. So that's what is important. I think we can take some questions and then the other can, because I thought that I should explain in detail, and in case there are questions.
Not really. Nothing new. I think we've already taken all the questions. One of the questions that came, and I think we can talk about this, is that how many years of records and financial statements of CD should be asked by the IRP/RP when he takes custody possession. So my opinion here is that there are various laws which are applicable to various companies depending on asking them to maintain records for a certain set of years. Income tax would have one number, Companies Act would have another number, GST law would have another number. So the record keeping should be based on at least the law that is applicable. Similarly, statutory auditors are required to keep records up to certain number of years. So that was my take.
Yes, Ankit, you're absolutely right. See, some cases 8 years and some maybe something, because I think the 8 years is the appropriate number of years.
Then there's a question that if directors or erstwhile personnel are absconding, then the only way that one can look for, or one can apply under 19.1 or 19.2, serve these notices to whoever is available or is understood to be available, associated with the management or with the company or as a promoter. In case they're not available, then one can always file an application to the NCLT saying that yes, you tried serving these notices, or you send the notices to the email addresses that are available for the directors or the promoters on MCA. MCA has email addresses of all the directors. All the companies also have an email address which is publicly available. So that is the official email address of any company or any director which is on record and which is publicly available. So that can always be used. COC may be authorized for delay submission of assignment of debts with at least 66% of voting share. So that's one of the recommendations that has come from one of the participants. Then in 19.2 application, NCLAT remands order of NCLT, thereby RP is left standing without getting info for months. So 19.2 application, NCLAT can remand it to NCLT, but the change in law now is that NCLT would have a clearer picture of what all information which was required to be shared is not available. So that will help. So that's about it. I think we are anyways over time, so we can wind up.
Thank you very much. Thanks a lot, lovely audience, and please do sending your questions. We'll take up in the webinars. The next webinar that we are trying to combine with is the new process for the registration as IBBI, and maybe that we also will take up the one-time settlement circular which has been released by RBI. So thank you, friends. Thanks a lot.
Thank you, everyone.